Hello everybody, and thank you for joining us. Good morning, good afternoon, good night, wherever you are. And thank you very much for being here. We are here today to launch a new report, so maybe I'll actually start sharing my screen. I hope you can see this. To launch a new report written as part of the ChainGE Lab ERC research project and community. My name is Hila Shamir. I'm a professor of law at Tel Aviv University, and I'm the principal investigator of ChainGE Lab. And before I introduce the report itself, I'd like to begin with gratitude. First, I want to thank Debbie Seaton so much for her tireless, meticulous and thoughtful work that made it possible for us to bring this report to launch in good time. So thank you, Debbie. To our research assistants, Eden Engel and Suad Baloum, who helped us map and understand the complex landscape of transnational labor litigation. And to all of the participants, the lawyers who litigated these cases and the scholars who study them, who generously share their experience, knowledge, and time with us. We're especially fortunate that some of you are here with us today as respondents and otherwise, so thank you for joining us. And of course, my deepest thanks goes to the report's main author, Urmila Bhoola, whom you will hear from shortly, and I'll introduce her later. So let us begin. So this report, that if you haven't read yet, is already on our website, and you can access it here. Transnational litigation to enforce workers' rights in GVCs grew out of an attempt to understand, following other scholars in this field, why what seems like a really promising tool to enforce workers' rights in GVCs, and if you talk to anybody who's not a lawyer, they have this big faith in transnational litigation. Why is it so difficult? Why is it such a hard case to make? And often doesn't quite reach the desired outcome of expanding lead firm liability to workers' rights violations. So we wanted to understand what are the legal mechanisms at play and what impact does transnational labor litigation manage to have in the courtroom and outside the courtroom. As many of you here know, the challenge of transnational labor litigation seeks to address stems from the fact that across GVCs, lead firms coordinate, price, audit, profit from production across multiple jurisdictions. Yet when workers' rights are violated and workers are harmed, legal responsibility is often confined to the lowest tiers of the chain. Transnational labor litigation is one mechanism that tries to address this, and this report examines transnational labor litigation as one of the key mechanisms through which this structural gap is currently being challenged, although there are others. So at the heart of this report is what we describe as a structural tension, right? Production today is organized transnationally across networks of suppliers and contractors, but labor law and corporate law remain largely territorial. Labor law is built around the dyadic employment contract, but GVCs, by contrast, are structured through networks of contracts in which lead firms have no direct contractual relationship with workers. This disconnect produces a persistent accountability gap. Against this backdrop, transnational litigation appears particularly promising. It's one of the few available instruments that can pierce the territorial and institutional boundaries, shielding lead firms from liability. Through tort, negligence, consumer law, forced labor, trafficking claims, workers and their advocates have sought to extend domestic legal accountability to multinational corporations whose operations span multiple jurisdictions. So litigation really offers the possibility of converting the moral and political commitments embedded in international norms into binding obligations enforceable in domestic courts. However, as so many people involved in this here know, and as we show in their report, despite its promise, it still operates within the very legal architecture that enables and sustains supply chain capitalism. And we frame in this report transnational labor law litigation, therefore, in three ways. First is a key mechanism used to confront the structural tension. Second is a strategy of resistance to the legal architecture that distances economic power from legal responsibility. And third is a contested site of norm translation. And by that, we mean litigation is not just about winning or losing cases. It's a site where international labor norms are negotiated, translated into domestic legal doctrines, and where courts negotiate how far responsibility can travel along the supply chain. The report bridges two influential ways of thinking about transnational labor litigation in the literature. One way, as Ebony Birchall and her colleagues showed in their 2023 report, strategic transnational labor litigation can drive systemic change, right? It's reshaping corporate behavior, influencing policy, even where the claimants do not win on the merits. The second approach that Fudge and Mundlach demonstrate in their influential piece about this is that judicial reasoning itself helps constitute supply chain capitalism, the doctrines of jurisdiction, privity, corporate separateness, sustain a global economic order that distances lead from liability. So in this report, we argue that transnational labor litigation is neither simply reformist or simply constrained. It operates both within and against the architecture of supply chain capitalism, shaped by doctrines that sustain corporate impunity, even as it seeks to challenge them. Its significance lies not only in courtroom victories, but in the process of legal translation they set in motion, in how they reinterpret tort, corporate, and contract doctrines in light of transnational labor norms, mobilize new legal communities, and create the foundations for emerging statutory regimes of accountability. So our purpose for the report is really, we have these four aims. First is just to have a synthesis of 3 decades of landmark labor cases across various jurisdictions, the US, Canada, Germany, Brazil, the UK, Malaysia. Second, to map recurring procedural and doctrinal barriers, so really have a very close reading of the opinions and highlight emerging legal and regulatory pathways. Third, to examine the strategic practices of litigators and advocates in this field, a lot of innovative work that goes into these cases. And fourth, we hope it can serve as both an analytical and practical resource, a diagnostic map for practitioners and researchers. By identifying where claims are foreclosed, where openings emerge, and how litigation interacts with regulatory reform, we hope the report offers a strategic map for future action. So the structure of the report, it's organized around 3 themes. First, the procedural closures. So cases like Rana Plaza, Kik, Nestle, Kubali, and Apple show how claims are often foreclosed at the threshold, right? Already stopped through jurisdiction, limitation periods, standing, or really narrow interpretations of duty. But second, we do trace moments of doctrinal breakthroughs. Cases like Vedanta, Nevson, and Okpabi demonstrate conditional openings, cracks in the legal architecture of supply chain capitalism, where courts reinterpret existing doctrines to allow claims to proceed. And third, we study statutory and HRDD, human rights due diligence mechanisms. Here we examine how litigation interacts with regulatory reform, with due diligence legislation and administrative enforcement, especially in Germany, France, and Brazil. So taken together, these strands show that litigation does not dismantle supply chain capitalism by any means, but it can create these cracks, as I said, in its legal architecture and find new ways for claims of workers to reach lead firms and seek responsibility. So with all that, I now turn to Urmila Bhoola. She brings an extraordinary combination of judicial, international, and advocacy experience to this project, and many of the insights in the case analysis are deeply shaped by her long engagement with questions of forced labor, modern slavery, and corporate accountability. And Urmila will walk us through the key cases and the doctrinal dynamics that emerge across jurisdictions. So Urmila, the floor is yours. I'll keep following the PowerPoint. And you're on mute, so just unmute yourself.
Thank you, Hila. And thank you to you for your support with the preparation of the report, and thank you also to Debbie for your amazing attention to detail and your input. Can you hear me clearly?
It's a little disconnected.
The research methodology consisted basically of the
No, now we can't hear you at all. Sorry. You want to try without the headphones? Oh, it worked perfectly before, and now I can't hear you. Can we try again?
Started and it was fine. So, all right, is that clear now?
Yes.
Okay, good, thank you. So in terms of the methodology, there was a doctrinal analysis having regard to judicial decisions, pleadings in some cases, court filing, petitions, as well as looking at some of the statutes and the wording of statutes and some legislative debate around statutes and definitions. More importantly, the quantitative research consisted of the interviews with the 12 practitioners Hila has mentioned, and I'm really pleased that
Urmila is kind of
you are here
disconnecting
today,
again.
and I'm really grateful to all of you.
I don't know what to suggest. Here, when you get closer, it's okay, I feel.
Okay, so maybe the microphone on this is not working, but I am moving closer to the laptop. Does that help? No?
It does a little bit.
Okay. All right, let me just try and continue. So the empirical research consisted of the interviews with the 12 lawyers. We covered 6 jurisdictions and more than 20 cases, as well as the academic committee on the cases analyzed in order to complete the research for the report. Okay, thanks. Next slide.
Okay, we still don't hear you that well. I'm sorry. We hear you with a great delay and with some disconnect. So let's try to continue and see what happens. Maybe it will work itself out.
Okay, this is exactly what I was praying wouldn't happen. Okay, when we talk about the legal terrain of transnational litigation, we see that the courts have dealt with this similar issues. Still not happening? Not hearing me? No. Okay, I'm not sure what to do to fix this. I'm really sorry.
Urmila, do you want to try to disconnect and connect again? Or Debbie, do you have a thought what you can do? I see, Debbie, that you're thinking about it.
I'm just thinking if there's some way on the Zoom that we can put the text transcript as it speaking to show what's. I think there's a way to do that to show the like a closed caption.
But yeah, I'm not sure that will solve this here though.
Because it's
maybe
not
if we'll close
clearly.
the video, it will help.
Maybe
if we'll close the video, it will help the internet connection.
Maybe let's talk about. We talk about the legal terrain of transnational labor litigation as consisting of the expansion of the duty of care in the UK and Canada. In UK, we found that the courts recognize that parent companies may owe a duty of care to workers and communities harmed by conduct of their subsidiaries, based on their actual involvement rather than formal control or ownership of the subsidiary. In Canada, we see that the Canadian Supreme Court recognized that international customary law norms can give rise to domestic remedy for forced labor and slavery against corporations. Is that working now, Hila?
Just continue. I think it's good enough. I'm not sure we can make it any better. I'm just trying to make this lighter on your bandwidth by turning off my camera so you can continue talking. So just go on. I'm with you.
Okay. 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 In Europe, issues of jurisdiction have actually permitted claims. EU instruments allow access to courts. So, for instance, the Jabir versus Kick case, Germany was allowed to proceed. The court had jurisdiction, but the instruments require foreign law application. We also see in Europe there's an emerging trend towards human rights due diligence legislation, which represents a shift towards preventive regulation. The experts that I interviewed identified a number of cross-cutting barriers that impact on transnational litigation, and many of those result in having an impact on the outcome of litigation. Thank you. The first theme under which we analyzed the cases was the procedural closures. This is exactly represented by the Rana Plaza decisions, where two cases brought to seek civil claims on behalf of families. Now, despite the evidence of unsafe conditions and lack of structural safety, the civil claims did not proceed against the major buyers. The courts treated the tragedy as legally disconnected from corporate power. They applied territorial choice of law rules and narrow duty of care frameworks. In terms of sorry, could you just go back one slide?
Urmila, we're not hearing you. I'm sorry. Is there any way you can maybe switch to your phone, or maybe you can turn off your camera and we can see if that's better? But we can't hear you now either. Sorry. I'm so sorry.
Okay.
Sorry, everybody, for the technical challenge. Here, now we can hear you. Go on, Urmila. We can hear you.
Oh, okay. Did you hear me just now? I'm also just,
yes.
Sorry, I'm just trying to change to a different router.
I think this is fine now, Urmila. Just carry on.
But I think, okay. We see the closure mechanisms that apply in that case is the Bangladeshi limitation periods for closed claims. So there's a statutory limitation. The 1 year had expired and the claims could not be brought. The codes of conduct that were applied by the companies that applied to the suppliers in Bangladesh were treated as non-binding governance. Supply chain workers were deemed to be legal third parties to which the buyers owed no duty of care. And corporate distance between the buyers and the supplier was preserved through formal legal structure and formal corporate structure. Next slide. In EU, we see as an example of procedural closure, although jurisdiction of the court was allowed, there was no remedy. The court applied Pakistani law, and again, the statute of limitations applied, and the claim was not dealt with on its merits. So we see an example here where private international law rules and EU regulations, in a sense, operate as gatekeeping and prevent claims from being heard on their merits. When we look at procedural closures in the US, the Nestle case, which Terry Collingsworth was involved in, and the Human Trafficking Legal Center, the Supreme Court dismissed forced labor claims holding general corporate activity in the US by US corporations insufficient to overcome the presumption against extraterritoriality. So the Alien Tort Statute was held not to apply to conduct outside the US. In the Kubeli case, standing was refused, so the workers were not allowed to proceed beyond the threshold. The court required specific traceability. They required workers to identify the specific farm and plausible links to the chocolate producers. The supply chain opacity then became a jurisdictional barrier to the claim. In the Apple case, we saw that the court found an ordinary buyer-seller relationship is not sufficient for liability under the Trafficking Victims Protection Reauthorization Act. Even though there was some evidence about market power and the power of the tech companies to control production through being able to audit the supply chain, that was insufficient to establish the possibility of liability. So a very limited framing of venture liability. And again, this was a case Terry was involved in, as well as Kubeli, and also Martina and Maggie from the Human Trafficking Legal Center were involved as amici. So they played quite an important role and may want to comment on the procedural closures in these cases. The doctrinal breakthroughs that are significant, and this is the second theme of analysis, occurred in the Vedanta and the Akpabi cases, where these are not labor rights cases, but they landmark decisions which open the space for labor rights litigation. The UK Supreme Court in Vedanta held that determining parent company duty of care in relation to third parties and the conduct of a subsidiary is a fact-sensitive exercise. It's not determined by formal ownership or control. So the courts examined the actual role of the parent company in managing, supervising the operations and conduct of officials and employees in the subsidiary, but also its public representations around environmental responsibility and sustainability. The second issue was the access to justice issue, which often arises in considering whether the case is before the appropriate court, the forum non-convenience claim, the forum non-convenience point. And the court allowed the case to proceed in the UK against both the UK company and the mine in Zambia, not only finding that, the court found that although Zambia might have been a more appropriate jurisdiction, the question of whether substantive justice will be available was is more appropriate in the UK courts. And this is one of the many cases that was brought by Leigh, and we have Liberty Bridge with us who may want to comment on the case as well. The court took the approach of looking at group policies where Vedanta took the responsibility for group-wide standards relating to environmental safety, active supervision through implementing providing training for implementation and monitoring compliance, as well as public commitments in which Vedanta held itself out as exercising control over its subsidiary. And then in Akpabi, the court reinforced what had been decided in Vedanta and confirmed that it was corporate practice, not just structure, which must be examined in order to determine possible liability. The next doctrinal breakthrough was in the Nevson case, and I think we may have James Yap with us, who was legal counsel in Nevsun, and we'd be happy, James, for you to comment and to contribute your views. Where the Supreme Court of Canada held that customary international law automatically forms part of Canadian common law, where corporations are not categorically immune from liability, and the applicability of the decision to and the possible liability of corporations was referenced by 5 judges. So the majority of judges, although not in the majority decision itself. The court also held that Euskogen's liability, i.e. for very serious human and labor rights violations, which are and for rights which are obligatory, may grant civil claims. So this is a landmark decision where an apex court has made a decision which repositions international human rights and labor rights norms as part of domestic legal fabric of Canada, which can generate corporate accountability. The third stream we focus on is on statutory and human rights due diligence mechanisms and litigation diversification. Litigators and workers' organizations have pursued multi-pronged strategies of accountability alongside tort claims, which are extremely limited in delivering access to justice and remedy to workers. The first of these is consumer protection, and international rights advocates and Terry Collingsworth have brought a number of complaints relating to false claims about ethical sourcing under state consumer laws, targeting corporate reputation and market access. IRA has also litigated in terms of regulatory enforcement and blocking imports of goods produced through forced labor under the Tariff Act. Thirdly, we see the emergence of human rights due diligence legislation in France, Germany, and Norway, which impose binding due diligence obligations. But of course, civil liability is extremely limited, and France is the only country which allows for a limited form of civil liability. But enforcement is primarily administrative. And then lastly, we see the significant role of labor inspection and administrative enforcement in Brazil. And we cited the Zara case as a key example. And I'm very pleased that we have Professor Livia Miraglia and Fernanda Melo with us from Brazil, who are with the University of Minas Gerais Federal and Trafficking Law Clinic, as well as being involved as worker representatives in a number of cases, who have talked about the system of inspection in Brazil, where inspectors basically can pierce the contractual structure and identify the lead firm as a real employer under labor law, which can lead to prosecution of that firm before the labor court, as well as the listing of, once there is a decision against them, listing of that corporation in the dirty list. Lastly, then, to turn to the discussion of the issues raised in the report and the issues that Hila raised in the introduction. We see firstly that there is fragmented governance in this universe, really, where there is a disconnect between what exists economically in terms of global economic power and the rights of workers and national laws which govern remedy for workers. So transnational labor litigation operates within a fragmented governance landscape. Secondly, we see that there are procedural barriers where these barriers and selected judicial openings create an uneven terrain in which to establish corporate accountability. Lastly, despite the lack of decisions on merits, litigation operates as a catalyst for change. It can prompt changes in corporate conduct. It can influence law and policy reform, even if it does not always result in remedy for workers. Fourthly, the effectiveness of interdependent mechanisms and working in jointly to ensure the effectiveness of such mechanisms, the interaction of litigation and its interaction with other governance mechanisms, as well as the ability to strengthen worker voice and agency is critical. And then lastly, the main point that emerges is that despite its limitations, litigation can and has been seen to contribute to cracks in the legal architecture of global supply chain capitalism. Thank you. I'll pass back to Hila, and my deepest apologies for these issues.
Thank you, Urmila. We could hear you perfectly at the end. So everybody who wants to turn on their cameras, you're welcome to do it. So let me just conclude by kind of 3 takeaways that we have from this report, and then we'll move on to the respondents. So the 3 takeaways from our report is that transnational labor litigation is neither a cure nor a dead end. It operates within this fragmented governance landscape, and procedural barriers remain formidable. But second, that there are selective judicial openings, that this step-by-step that we see in litigation in some ways is creating something new. I think we're still in the process. I mean, when I'm hopeful, I think we're still in the process. And we see that in Vedanta and Nevsin and Okpabi that demonstrate that corporate non-liability is not immutable. Doctrinal constraints are not fixed. They're interpreted, and as such, they're dynamic. Third, the real significance of litigation so far lies beyond courtroom victories. Even where claims are foreclosed, litigation can shift public expectations. It can catalyze statutory reform. We saw that with KIC and the German HRD legislation, and they can reshape advocacy strategies. In that sense, transnational labor litigation functions as a contested process of norm translation, as I said in the opening, kind of opening these cracks in the legal architecture and creating space for new forms of accountability to emerge. But its effectiveness ultimately depends on something beyond the courts. It depends on strengthening worker voice, having an active civil society, having collective power to demand liability and accountability, and interaction between litigation and other governance mechanisms. So that's it for the report presentation. And of course, we welcome you to read it in greater detail. This was just an overview. And we're again apologize for the technical difficulties. But we're especially fortunate today, as Urmila said, to have with us several practitioners whose work really shaped the landscape of transnational litigation. We have with us Liberty Bridge, a senior associate solicitor at Leigh in the UK, whose work on parent company liability and access to justice cases has been central to the doctrinal breakthroughs we discussed. We have Terry Collingsworth, Executive Director of International Rights Advocates in the United States, who has litigated some of the most important forced labor cases under the ATS and TVPRA, including Nestle. We have Livia Miraglia and Fernanda Melo from ChainGE Lab, but also mostly from Federal University of Minas Gerais and the UFMG Clinic for Slave Labor and Human Trafficking in Brazil, whose work really demonstrate how labor inspection and administrative mechanisms can pierce the contractual form. And we have with us, I think, I didn't see her, I think, but I hope she's here, Miriam Saaj-Maz, the legal director at ECCHR in Germany, who has led strategic transnational cases such as KIC and has been instrumental in shaping HRDD debates in Europe. I think we have here with us as well James Yap, the legal counsel for the Nevsin case, and Maggie Leigh, the Deputy Director of Human Trafficking Legal Center. And we also want to welcome you to make comments as well if you want. And I just want to say that all of your work reminds us that litigation is not just abstract doctrines, right? It's built case by case, strategy by strategy, innovation by innovation, often over many years. So each one of our respondents will have about 10 minutes to discuss, and we will begin with you, Liberty Bridge. Thank you for being here with us.
Thank you so much. Yeah, good afternoon, everyone. Thank you for inviting me to speak, and congratulations to Urmila and the team on the report that I think captures with real clarity both the promise and the limits of transnational litigation for workers in global value chains. Can I just check that you can hear me? Just a second. Yeah, okay, great. I just want to check that there's no issues. So my name is Livia Bridge. I'm a senior associate solicitor at the UK-based law firm Leigh and specialising in international group litigation. And I contribute to this project through a fascinating interview with Urmila, drawing on what I kind of see day to day when workers try to use the courts to obtain remedy for harms that are transnational in fact, but still treated as territorial in law. And I'm actually going to speak briefly today about why, despite the obstacles, I think most of my colleagues in the UK remain cautiously optimistic about transnational labour and supply chain cases in the UK context. And firstly, I do want to emphasise the word cautiously. These cases, as many of you will know, are hard. They are fought as much on procedure and access to evidence as on merits. But, and this is the optimism, the direction of travel in the UK, particularly in the higher courts, has been to keep the door open where there is a properly arguable case and where shutting the door would make remedy practically impossible in other jurisdictions. So I'll start with my first reason for optimism, and that's that the UK Supreme Court has done something very important for this field, in my opinion, and it's clarified the legal approach to parent company responsibility and to the threshold question of whether the claim should proceed past the early gates. And as was mentioned in the presentation, in Vedanta, the Supreme Court confirmed that claims by overseas claimants can proceed in England when there is a real issue to be tried against a UK domiciled company and where there are serious concerns about access to substantial justice in the alternative forum where the harm may have actually taken place. And then further, in Okparby and Shell, the court reinforced this parent company duty of care is not actually a special category, but simply turns on orthodox negligence principles, including what a parent actually does in practice, so their group policies, control, oversight and implementation. So I suppose that leads back to why does that make me optimistic? Mainly because it gives claimants in court kind of now a workable map. The question is no longer can a parent ever owe a duty, but what is the evidence of de facto management, assumption of responsibility, and the operational reality behind the corporate structure. And then my second reason for optimism is more practical, and it's more the fact that UK appellate courts have increasingly signalled reluctance to dispose of these kinds of claims at a very early stage where key facts are contested and disclosure hasn't happened. And in Okparby, the judgment clearly highlights the court's concern that claimants often don't have access to internal corporate documents and that disclosure in these cases is crucial. The judge in Vedanta actually said that it was blindingly obvious that the disclosure in these cases, it was what the case was going to turn on. And so they weren't prepared to kind of get rid of the cases at this early stage. And outside the classic parent subsidiary pattern, the Court of Appeal also in Begum and Moran refused to strike out a novel negligence claim connected to overseas harm, explicitly recognising that this is an unusual extension, but still allowing it to proceed to trial level determination rather than it being killed off at the early pleading stage. And so this doesn't mean that claimants always win, obviously they don't, but it does mean that the courts are increasingly prepared to let properly arguable cases reach the stage where facts can actually be tested. And that matters because, as we all know, without that, rights never translate into remedies. And then third, and probably most relevant to labour exploitation claims, is the growing willingness of UK courts to engage with claims that are not just about subsidiaries, but about value chains and suppliers. And the most concrete recent example is Limbu and Dyson, and the UK Supreme Court refused permission to appeal a Court of Appeal decision, allowing migrant workers' claims to be heard in England rather than Malaysia, meaning that the claims can and will proceed in the English courts.
Recording in progress.
And this Supreme Court case 3 records that the allegations concern forced labour type conditions in Malaysia. supplier factories, and the dispute at the stage was about forum, England or Malaysia, not the merits. But what makes me cautiously optimistic for the broader category is not that it proves liability, because it doesn't, that it demonstrates that where claimants plausibly connect to harm to UK-linked entities' practice, policy, standards, oversight, decision-making, English courts may, and probably more likely than not, will be prepared to hear the case here. And importantly, Dyson demonstrates that the courts will give real weight to practical access to justice barriers faced by vulnerable claimants when asked by defendants to send claims elsewhere. And fourth and finally, I'm cautiously optimistic because in the UK, there are established mechanisms to manage cases brought by many claimants. And in labour exploitation context, scale can often be the defining feature. So you may have heard of group litigation orders, GLOs, and other multi-party tools allow courts to manage common issues efficiently. And even though the UK model is typically opt-in rather than opt-out, the Civil Procedure Rules practice directions set out how GLOs operate and applications, group registers, managing judge and case management. And so that really helps to kind of move the cases forward. And the English courts have developed multiple collective procedures, and these tools have also grown alongside litigation funding and just a broadening of specialist claimant practices in the UK. And as was touched upon in the report, this procedural capacity matters, and it's one of the reasons why the UK remains a serious venue for transnational claims, where individual claims would otherwise be too small, too risky, or too fragmented to bring. So I'd say I was cautiously optimistic. So I'm just going to finish off with just a few reasons why I'm kind of cautious, just because obviously without it, optimism would just become wishful thinking. Firstly, my view is that the defendants will always keep fighting on procedure. I think Urmila makes quite a few references to this in the report, and some of them are attributed to me. And I think that just the fact that these claims remain extremely vulnerable to procedural attrition. Obviously, these are defendants with large budgets, with instructing city law firms who are kind of on retainer just to kind of keep pushing the case to drag it out as long as possible and to kind of wear down the claimant lawyers. Jurisdiction disputes is one thing. We've had libel kind of proceedings, limitation arguments, necessary and proper party fights, and all the kind of satellite litigation that can take years before any merits hearing takes place. And then, so for example, Begum and Moran that I mentioned earlier, while the court did allow the claim to proceed on duty of care arguments, limitation issues were central, illustrating how a case can still be derailed by kind of technical constraints, even after surviving strikeout attempts. Evidence and tracing remains a serious obstacle in supply chain case. Supply chains claims often rise or fall on the capacity to trace relationships and demonstrate what a UK-linked entity knew, required, controlled, or failed to act upon. There's mentioned in the report of the BAT Imperial Malawi Tobacco Farmers litigation that I also work on, and it's kind of a prime example of the opacity problem, like allegations of forced and child labour in an opaque value chain, with disputes over proof of supply relationship and where records sit. And even when a claim here is allowed to proceed, so it didn't get struck out after the defendant's initial application, the evidential slog of kind of progressing the case is substantial, and disclosure battles kind of years in the making. And obviously post-Brexit in the UK, the discretion that the courts have does add unpredictability. Dyson was the first jurisdiction case heard post-Brexit, but there is greater scope now for UK defendants to argue that England should decline jurisdiction in favour of another forum, but it doesn't automatically mean that they will. So yeah, headwinds remain, but they are not the whole story. But yeah, even the act of litigating, I think surviving early strikeout attempts, obtaining disclosure, forcing clarity on corporate governance, they can shift norms and incentives before a final judgment, because hopefully it's changing the broader picture of what boards, auditors, and procurement teams are thinking about and treating as a legally material risk. And more than anything, it can also result in life-changing settlements for our clients, which, although may be frustrating in the abstract because it doesn't push the law forward in the same way, as it would do if the case was successful at trial. What it does do is, achieve justice and remedy for our clients, which obviously is our main aim in these cases. So that was kind of a whistle-stop tour of why in the UK we kind of think that hopefully the future is bright for these cases. Thank you.
Thank you so much, Liberty, for making these optimistic comments, but also realistic. We'll move to Terry Collingsworth. Thank you for being with us from International Rights Advocates in the USA.
Hi, thank you, and congratulations on the report. It was very, very helpful, even to me, and this is the area I work in, just to see the comparative analysis. And as a whole, I think we should all remain cautiously optimistic that if we fight and continue to fight, we're going to make progress here. I want to mainly give some updates and perhaps clarifications, because the cases that are reported in the report from the United States all seem pretty bleak, but in many cases, those were the beginning, not the end of a process. That is not true, however, of the first analysis of Doe v. Nestle and the Alien Tort Statute. That decision, I just have to comment that, the Supreme Court is very, very right-wing now in the United States. But that decision was particularly dishonest and was just a plain power grab by corporate America. The U.S. Chamber of Commerce and several large corporations, including Chevron, submitted amicus briefs basically telling the Supreme Court that how in the world are we going to operate in the global economy if we are held accountable for legal norms in our supply chains and otherwise. And the court bought it. I mean, that they had to figure out a way to do it. So what happened was the justices who claimed to be originalists, the people who claimed they're just reading the text, we're not putting our views into it, they invented this incredibly complicated and until then non-existent extraterritorial test to see if the case can extend beyond the U.S. borders. So they said that you have to touch and concern the territory of the U.S., which in the Doe v. Nestle case pretty much meant that Nestle and Cargill would have had to kidnap children from New Jersey and take them to Africa and make them work. I mean, it's just a ridiculous bastardization of the statute. So as soon as that decision came down, a group of us working together on these issues, we had an amendment ready to go that simply says the Alien Tort Statute applies extraterritorially. But our Congress is so right-wing right now that we can't even get that moved. But it will come. There will be a day when we are not controlled by right-wing lunatics and we can make a little bit of progress legislatively to clean up some of these errors by the courts. A little bit of more bad news is that my colleague Paul Hoffman in the Ninth Circuit Court of Appeals had a great decision under the Alien Tort Statute against Cisco Systems for having designed in the United States, and it was paid for in the United States, a surveillance system that they sold to the Chinese government, which used it to surveil Falun Gong and other groups that they were suspicious of. And they brought a case in Los Angeles against Cisco Systems, and the Ninth Circuit approved the case and said, yeah, it does touch and concern the United States because everything that was important about it happened here. Unfortunately, the Supreme Court accepted cert in that case, and the argument is on April 28th or so. Paul Hoffman is arguing that. There's no way in the world they took this case to give the Ninth Circuit a pat on the back. We can expect an even worse decision making the Alien Tort Statute even more impossible to use. So until we amend the law, it is now useless as far as I'm concerned. I don't even consider it. It just would be a waste of our limited time. Jumping down to the Trafficking Victims Protection Act, your report mentions Kubali and Apple. Both were brought under that statute. The Kubali case was dismissed without prejudice, which means that we are able to amend it. So we are in the process of doing that. We're tightening it up, have a couple of different legal theories. So we will be refiling that. And I think that, really is illustrative of the nature of this work. You get a loss. You don't just say, oh, well, too bad for the plaintiffs. No, you figure out how you get around that bad decision and you try again and again and again if necessary. But that's what we're doing with Kubali. In other cases, TVPRA news, I just argued a case in the DC Circuit Court of Appeals against Kimberly-Clark Corporation and Ansell for using forced labor in Malaysian latex glove factories. And there, I think we came a lot closer to meeting what the Apple court's standard for a venture is under the Trafficking Victims Protection Act. And we also use an unjust enrichment theory that I borrowed from some of Leigh's great work in this area. And it appeared to get traction. The judges were very interested in unjust enrichment and really grilled Kimberly-Clark's lawyer about why it wouldn't apply. So you have to be optimistic to do this work, but I'm cautiously optimistic that we might actually get a win in the Kimberly-Clark case. We also have a case filed against Starbucks in Brazil for using forced labor in Brazil that is on appeal. It was just dismissed for lack of personal jurisdiction in the District of Columbia, so we're refiling it in Seattle, Washington, where Starbucks is headquartered. But we think we have really good, strong facts there to continue to try to utilize the Trafficking Victims Protection Act. I want to briefly talk about something that we just started doing that is working out very well. So in my mind, the crime, these corporations are all trying to have it both ways, right? They put out these codes of conduct and policies. Most of the cocoa companies say we have zero tolerance for child labor, and they write these great reports talking about how they're making progress in solving this child labor problem that they acknowledged going back to 2001 when they all signed this voluntary protocol called the Harkin-Engel Protocol. So they're making all these promises to the public. But when they show up in court, then they completely go 180 degrees in the other direction and say, we have nothing to do with this. What do you mean we're responsible? We just buy cocoa, or we just buy cobalt from mines in the DRC. We have no idea what's going on. So they're having it both ways. So a group of lawyers, we began discussing here that we ought to be using their promises to the public more offensively. I've teamed up with a really, really good consumer fraud firm called Richmond Law and Policy, and we have filed a series of cases just under consumer fraud statutes in the District of Columbia, basically saying, so our first case was against Mars, Mondelez, and Cargill. We took all of their statements that they're promising the public they have zero tolerance for child labor, they're helping the farmers get a better income, blah, 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 all the lies they're telling. And we sued them for fraud and said, well, here's the reality. Here's research we did. Here's a picture of a kid on a Mars plantation using a machete. Clearly, you're not keeping your promises. So echoing what Liberty said, they removed us to federal court. They're trying to delay it forever. We had to go through about a year's process to get them back in the DC State Superior Court. And we did. And then we just got a tremendous decision about 3 weeks ago that it's on our website now called Kassim, Kassim versus Cargill, where the court denied their motions to dismiss and said, yep, it looks like you made these statements. The plaintiffs have shown that they appear not to be true. So the case can now move forward, which means we get discovery and can finally get their internal documents to learn a lot more about what they know about their abuse of children in their supply chains, et cetera. So we have now pending cases based on that success. We have sued Apple, Tesla for returning back to the Congo, where we did all kinds of research showing that they are using cobalt mined by children and other forced laborers under horrific conditions. So we filed consumer fraud cases against them. We filed one against Nestle. Basically, we're having a great time just researching on the web all the lies these companies are telling and saying, all right, we're going to hold you responsible. So under our law, they have two choices. They have to either stop lying, and we will get injunctive relief, attorney's fees and costs and all of that. They can just take their statements down and say, nope, we don't have a clue what's going on, and we're going to make money anyways. Or they can make them true. They can make their statements actually true. If you say you don't have child labor, have zero tolerance, and you're helping the farmers, well, make that happen instead of just lying about it. So I am now very optimistic in my limited time left on earth that we're going to finally get some accountability, and we're going to sue everybody who's lying about their supply chains, the conduct in the countries where they're operating, the means by which they're profiting from exploiting people around the globe. And so I think that you'll see a little bit more action. And the good news is these are in state courts. We're using state law, and we don't need the federal courts that are gotten so political and right wing to bless our actions here. That is encouraging. One other case to report on that should soon be resolving is we sued Chiquita back in 2007 for using paramilitary groups in Colombia, the AUC paramilitaries, to provide security that murdered thousands of people. We had a jury trial in June of last year, 24, and won, and Chiquita appealed. We just had that argument. Paul Hoffman argued for our team, and we think it went real well. But the law that we used there was wrongful death law based on Colombian law, where the events occurred. That we're seeing more and more with our experiments that we don't need these complicated federal statutes to achieve accountability, that we're going to rely more on state law, nation law, and just what we would call the common law to try to get accountability for our clients. So I'll stop there. I think I would not be optimistic about the alien tort statute until we get congressional reform. But there's lots of other things we can and are doing to hold corporations accountable, even in the face of this incredibly negative political environment that we face here in the United States for the next several years. And thanks again for the report. I think it's going to be helpful.
Thank you so much, Terry, for your energy, optimism, and everything you're doing in this field. It just sounds amazing, and we just will definitely follow. Keep us updated. So we're moving now to our next respondents, Livia, Miraglia, and Fernanda Melo. The floor is yours. Who's going to start? Livia?
Okay, I think I'll go first, right, Fernanda?
Thank you.
Okay, so thank you, Hila. Thank you, Urmila, so much for this very rich and careful report. I will briefly comment on two aspects of the Brazilian perspective of it. First, the way the report frames Brazil's statutory approach to corporate accountability, because it's different from the other cases on the report. And second, my impressions from the Brazilian institutional reality, so we can all be at the same page. So regarding Brazil's statutory approach, I think the report is very accurate, and it captures something distinctive about our model. Accountability here has historically developed less through private tort litigation and more through public enforcement mechanisms. So in Brazil, I think this is something really peculiar of the country. The labor inspectors, the labor prosecution office. First, we have labor inspectors and labor prosecution office and labor court, all specialized. So, and they all played a very central role in these cases. And instruments such as administrative fines, public civil actions, class actions, and all this other mechanism we have, especially the dirty list, which is a mechanism that has been created for forms of accountability, are not primarily grounded in negligence doctrine, but in labor law reasoning and public enforcement. So the report is also and the report is also correct in identifying that Brazilian labor law doctrines such as primacy of reality over form, subordination concerning the characterization of employment, economic group liability, the idea of ajenidad. I don't know how to translate to English, so I translated to Spanish. But anyways, have allowed courts to pierce contractual structures and supply chains. So the Zara case is very emblematic, but it's not based on supply chain responsibility. So it's kind of different from what you guys are always dealing with. It has not framed primarily as a tort case also. Instead, the labor authorities in this case and the courts look beyond the contractual facade and focus on control, economic benefit, and structural subordination. So they understood that Zara was not only liable for the labor situation, but Zara was the real employer of that people over there. So it was a economic group, not responsibility on the supply chain. So, and this is very good for us. This was very good for us because after the Zara case, we had a very big labor law change in Brazil. And from 2017 on, outsourcing now is legal in every single case in Brazil. So a company can just outsource all of its supply chain, and that's legal in Brazil. But the argument in the Zara case that the Zara was the real employer, it still can be used for other cases to make big companies responsible for cases of human rights violation. And this is what we're seeing in the recent jurisprudence in Brazil. So recent in other cases and other cases on the textile industry, but also other industry, we are seeing an emerging narrative suggesting that regulation, well, this is, okay, so I said the positive side, so now going through the critical and negative sides. So we have this Zara case and other big cases that were good, and that's a good jurisprudence we have, but we also are seeing in our courts in Brazil, especially on the Supreme Court, an emerging narrative suggesting that regulation can harm workers and that flexibilization may be better to promote inclusion than regulate labor laws. And this ideologically shift matters, and even and we have to get into the political account of it, as Terry said, that even though we are not in a right-wing government, and Lula is supposed to be a left-wing president, what we are seeing in the Supreme Court of Brazil, it's a right-wing perspective. So it's really, especially concerning labor law cases, we are having this really ideological shift that it doesn't communicate with the supposedly left-wing government we have. So just to wrap up, because Fernanda also wants to say something, and I don't want to spend all the time. Okay, so I kind of got lost in my notes. So that's the first thing. The second point, and also something that I would really like to highlight. So my overall impression on the report is that it offers a very sophisticated comparative account and connectly identifies Brazil as an example of an alternative accountability architecture outside tort-based litigation, which is great, and it does work here, but with this shift I'm telling you guys. But at the same time, I would perhaps add one cautionary note. The Brazilian modern model's strength has historically depended less on statutory innovation and more on institutional activism. particularly from labor inspectors and the labor prosecution office. So if institutional capacity weakens, or if courts reinterpret protective doctrines narrowly, which is happening already, the same statutory framework can produce very different outcomes. So I would frame Brazil not as a stable model, but as a contest space where strong legal tools coexist with political and judicial pressures toward flexibilization. And so, Fernanda, I'll leave the floor for you so you can complement.
So thank you, Urmila, Livia, Hila. Thank you, Urmila and Hila, for this important report, and also for allowing me to be part of it in some way. I especially appreciated this comparative perspective. It's very important to understand how the responsibility in supply chain in the world, and as always, your work is truly inspiring. And so if Livia showed Brazil as an important example of strong public enforcement, I would like to look at the other side of the picture, the structural limits of holding lead companies accountable. So one thing I really appreciated in the report is how clearly it shows that Brazil developed strong administrative tools outside the traditional tort litigation model. Like we have labor inspection, we have collective actions, and we have the dirt list, which creates real reputational and economic pressure. So yes, there is institutional capacity, but when we look at who is actually held responsible, especially in the sector I study, my PhD, so the steel supply chain linked to charcoal production, we see a very clear pattern. So responsibility usually falls on direct employers, small producers, intermediaries. So lead firms almost never appear, and this creates a paradox. Brazil has a strong enforcement, but inside a legal structure that allows responsibility to be fragmented along the chain. And this is connected with outsourcing. Like Livia told us about the outsourcing in Brazil. After labor reforms here 8 years ago, outsourcers became widely allowed, and even for core activities. So today, supply chains are legally divided. Economic power is often at the top, and legal responsibility stayed at the bottom. And this creates a gap between economic control and legal accountability. And I think the report showed this tension, principally in Brazil. So yes, there are important cases where courts here in Brazil go beyond contractual forms. And actually, just this week, only 2 days ago, a regional labor court in the state of Pará upheld the conviction of Volkswagen, a case mentioned in the report, recognizing supply chain responsibility. It was widely covered in Brazil media, which shows that these decisions are still hairy, but they are starting to gain more visibility. But these cases are still exceptions. And in practice, proving structural control or economic influence is very difficult, especially because access to information is limited. Brazil shows that strong administrative enforcement is possible, but enforcement alone does not change the architecture of responsibility inside supply chains. And maybe this is the main lesson of the global debate, and strong inspection is necessary, but it's not enough. And if legal responsibility does not follow the economic reality of supply chains, especially the role of the lead firms, accountability will continue to fall many of the weakest actors, and even when economic power is somewhere else. So that's it. Thank you.
Thank you so much, Livia and Fernanda, for this, again, complicated picture of reality on the ground, the legal structure, what can be done and what can't. And it seems like, all of you so far have been describing this very dynamic field. We're supposed to move now to Miriam Sajmaz from the legal director of ECCHR in Germany, but I'm not sure she's here. Miriam, are you here with us? I think she may have had problems joining us eventually. So I do see that James Yap is here with us and Maggie Leigh, who were also interviewed. And I don't know if either of you want to say something before we open it up for discussion? James or Maggie, this is your opportunity if you're interested in giving your input and your perspectives.
I mean, yeah, thanks, Hila. And thanks to both of you for this report. I guess I'll just introduce myself. I'm James Yap. I'm a Canadian lawyer. I was interviewed with respect to the Nevsun case that's mentioned in the report, on which I represented the plaintiffs. Yeah, I just want to say it's sort of like, in doing that case, we were inspired by a lot of the work that was being done in countries like, the US, notably under the ATS, and the UK and others, in trying to sort of like develop our own sort of case law and like legal theories about corporate accountability, and so it's great to, after all those years of hard work, it's great to see that the case is getting attention elsewhere, and potentially, hopefully, I guess, inspiring other work to continue on that path. But yeah, I think that a lot remains in a lot remains to be done. I have become a little bit skeptical about, no, not skeptical, but like to conscious of the limitations of these massive tort claims. And yeah, just kind of very curious to talk about where we go from here. I think massive tort claims will always have a place. But also curious to talk about what other forms of corporate accountability, legal corporate accountability there can be. I think those are my thoughts.
Thank you very much. I don't know, Maggie, if you can hear me, and if you're interested, if you want to join in, you can at any point. Let's open it up. We have about 15 more minutes for discussion. So thank you so much, Liberty, Terry, Livia, Fernanda, and James for contributing. And it was really fascinating. And I think we did hear, as kind of getting James' perspective from Nevsun to where we are at, and Terry's, and of course, the important work of Leigh, kind of Liberty's work. That there are some avenues that seem less possible now, but others are opening up. I think, Terry, you clearly pointed to that, but we also see the Brazilian case kind of giving us other examples from other jurisdictions where we can have, labor inspectors, and we can have other institutions involved rather than just courts. And I'd like to open it up to discussion, to everybody to ask additional questions or reflect more about optional strategies. And I see Alan Hyde has his virtual hand up. So Alan, I'm giving the floor to you.
Thanks, Hila, and thanks to all the authors on this terrific report and all those who agreed to be interviewed. I had two main questions. The first is Liberty referred to the impact of such lawsuits on the aspirations and organizing of the exploited workers. And I didn't see that in the report, and I was curious about it, whether we have any examples or data of the effect of such lawsuits in the developed world on the affected workers in the developing world. This to me would be important in deciding how important a priority these lawsuits should be. The second would be looking forward. Would it be valuable for people on this call or our students to draft a model litigation statute that could be enacted by a future sympathetic parliament in the UK or Canada or even the US Congress? I assume the EU is fully committed to its vigilance approach, which does nothing for me, or anyone else of whom I'm aware. The various procedural obstacles that it would be possible to draft a statute that clarified jurisdiction, forum non conveniens, got rid of some of the legal obstacles. Would that be a good project to do?
Thank you, Alan. So maybe I'll let Liberty and maybe Terry, already said that he has an amendment in his waiting for, but of course it's a specific amendment. But Terry, maybe we'll begin with you, and Liberty, if you're still there and can talk to us, would love to hear from you as well. So Terry, do you want to try and answer?
Sure, thanks. Yeah, well, I would say that because we have to be so conscious of the political environment that we are in, which is extreme. We were very conservative in what we were going to ask for in our amendment to the Alien Tort Statute. We were simply trying to solve the one avenue that the Supreme Court blocked, and that was extraterritorial jurisdiction. The statute itself, through lots of litigation, seemed to work just fine. That's why they had to make up this extraterritorial issue to block us. But the areas that could be legislated would include what torts are covered. In the Alien Tort Statute, the operative term is the law of nations, so that is a pretty good measure of what is universally condemned in the world. Things like genocide, torture, extrajudicial killing. What else would be forced disappearance, things of that sort that are universally condemned, forced labor, slavery. That would be one area to discuss. And certainly getting rid of defenses like forum non-convenience would be nice. I think it would be helpful to have a statute that people could look at and compare to their own law and say, well, this is what we need now. We're missing this part or that part. I don't think the U.S. would ever pass such a law, certainly in my lifetime, but I think we could plug some holes more likely. I will mention to your first question, Alan. We sued Firestone years ago in Liberia for running basically a forced labor plantation system to harvest latex. And the case was ultimately dismissed at the Court of Appeals because the court didn't believe it was forced labor when fathers took all of their children to help tap to make their daily quota. Ridiculously, Judge Posner, who's known for his law and economics theories here, said that they had a choice. It was the father's choice to bring the kids to work, even though he couldn't possibly make the quota by himself. But anyways, that litigation and the attention that it brought upon the plantation system in Liberia led to the replacement of a company union with a real trade union there. And they made immediate improvements for schools and hospitals and so on. So many people that were working on the case with me view this as a success, that if we hadn't sued and ultimately lost, none of these great things would have happened on that plantation. So there are those kinds of advantages. I would just make one quick comment while I have the floor, that the one thing I think we're all lacking around the world is the harnessing of consumer power. We keep trying to do that. We keep trying to get films and public relations communications going so that people can understand that they have the power of the pocketbook to just not buy these horrible products that until like supply chain issues are solved. That's just really, it's expensive because we're competing against the marketing budgets of Apple and Tesla and all of that. But it's still worth trying, and it's also part of an education process. I'll stop there. Thank you.
Thank you very much, Terry. Liberty, would you like to address Ellen's question?
Yeah, I think there's been a lot of talk, obviously, in Europe about introducing some kind of human rights due diligence legislation, and there's been a lot of talk by this recent government of like what they could do to potentially strengthen the law in that area so that companies take oversight of supply chains and stuff. I'm not as close on the details of it, so I can't really say I'm that kind of optimistic that it would have some kind of that effect, just because all these kind of legislations seem to take ages to actually kind of get anywhere, and then the mechanisms that they put in place are either voluntary or kind of recommended, or don't have any avenues of redress in them. But I think if we could, like, in a perfect world, formulate some type piece of legislation that had kind of proper mechanisms that would allow cases to be brought under, then that would be great. But I'm not sure in practice how it would work. And so I think using the avenues that we've got and trying to push it forward may be a better use of our resources. But perhaps that's my lawyer's head on rather than my kind of policy kind of advocate, change maker.
And what about Ellen's first question about the changes on the ground for claimants?
Yeah, so obviously Leigh Day cases come to us in a whole host of different ways, but they normally come to us via NGOs that have been approached by a group of workers. So the NGO, for example, we work on in the Dyson case, works with workers in Bangladesh and Nepal, which is where all of the workers in the case against Dyson were from, even though the kind of harm occurred in Malaysia. And so on the outset of any case, we will say to them, what do you want to achieve? And unless the main aspect of what they want to achieve is compensation, then chances are legal route isn't going to be the best route for them. Because if they wanted some kind of formal apology, etc., then they might not need to go down the legal route to get that, and the chances are the court wouldn't be able to hold them to that. Just like financial compensation would what been happened, but because they've been in such desperate situations, mainly kind of what they want is some kind of financial redress to be able to get their life back on track. So although the process has normally been quite healing, the fact that people have listened to them, they've been able to have their day in court, they've been able to, have like recognised plight, realistically, the financial remedy is what is going to impact them in the long term. But yeah, I think the question is quite a good one, and there might be kind of a further piece of research to kind of get their kind of like view on the whole litigation process and kind of the pros and the cons. I would say the cons for them definitely is just the length of time that it takes. I feel like it's very hard to comprehend that you speak to a lawyer and then 4 years and a Supreme Court ruling later, you actually know on like the merits of the claim, or what's actually going to be determined. It's just the fact that the case can be heard in the UK, and I think that can be quite difficult to comprehend for anyone. Never mind someone who's not kind of familiar with the UK legal system, etc., etc.
Thank you. Do we have a few more minutes? Do we have any other questions from the audience? Okay, in which case I think we'll end just in time. I want to really, really, really thank Terry and Liberty and Urmila and Fernanda for being with us and sharing your outlook on this. I think for me at least, I can say that it did give me some, as Liberty said, cautious optimism to hear about all these developments. I'm particularly interested, Terry, I want to say, with the consumer side and the consumer, as you just said. We actually, in this group, we have a big project on consumers now, so maybe we will might reach out to you again to hear a little more about this. But I think you're absolutely right that a lot of this just relies eventually in some way on consumers, but it's such a weak, eventually ends up being a politically a weak power politically, or non-power in some ways. And so the lack of structures for consumer representation and just is really quite mind-boggling in this environment where so much is allegedly dependent on consumers.
I'm putting in the chat right now the decision that we just got that blessed this approach, and I think that it really is promising that at a minimum you can get them to either stop lying or fix it. The decision is in the chat now.
Thank you very much. Urmila, do you want to say final words?
Yeah, I just want to say thank you to Liberty and Terry and James and for your participation, and Fernanda and Livia. It's been incredibly valuable. I thank you so much for enriching the report with your information in the interviews, and also thank you for your participation today, and thank you also to other colleagues. Thank you to you, Hila, for your support and your co-authoring of this piece, and bringing the kind of academic and conceptual framing to so what would have been a very dry legal analysis, and to Debbie for your editing support and your moral support as well. To all colleagues in the Rights Lab, in the ChainGE Lab, thank you so much. I think, I want to end. Sometimes we get very despondent about this area, but I do want to take on what Liberty said about being cautiously optimistic. And Terry, yes, of course, there are massive political constraints, the US, Brazil, everywhere else, but we just have to keep on trying to win rights for workers and continue to work with workers, and continue to forge a way forward to make labor rights meaningful in global supply chains and to make sure they are realized. Thank you.
Thank you, Urmila. Thank you, everybody. We will have a recording of this if you want to share with others. And again, if anybody doesn't want us to post this, let us know. Thank you very much. Let me just say that we have our next ChainGE Lab collaboratory meeting for those interested and want to join. On March 19th, we'll be launching a book about global business and local struggle, reimagining non-judicial remedies for human rights. So it'll be a complementary discussion, and we'll have the authors of that book with us. And if any of you is not on our list, feel free to email me and I'll add you, and you'll get to get notifications on our activities. So thank you very much, everybody, and I look forward to seeing you next time we meet. Thank you, and thank you, Urmila.
Thank you for a wonderful and enriching discussion. Thank you so much to all of you, and especially Urmila.
Bye, everybody. Thanks.
Thanks. Bye, everybody.